Hello viewers, I am Professor Sharanjit, working at the Rajiv Gandhi National University of Law, Punjab. In today's talk, we shall discuss defamation, malicious prosecution and nervous shock. We shall start with defamation. In the civilized world, reputation is the most valuable asset for every person, whether a natural person or a juristic person. Every individual tries to protect his or her reputation, character, and integrity. Defamation is a direct blow to a person's reputation, and it is considered both a crime as well as a tort. Worldwide, constitutional law gives great value to the freedom of speech and expression, particularly in vibrant democracies like India. However, while holding opinions and imparting information, a person cannot directly or indirectly tarnish the reputation of his fellow beings. In the case of Dixon versus Holden, 1869, it was rightly stated that a man's reputation is considered to be the most valuable property. A property lost can be recovered, but a reputation once lost can never be recovered. According to Winfield and Jolrix, defamation is the publication of a statement that reflects on a person's reputation and tends to lower him in the estimation of the right-thinking members of the society generally, or tends to make them shun or avoid him. As per Salmond, a defamatory statement is one that has a tendency to injure the reputation of the person to whom it refers, which tends to lower him in the estimation of right-thinking members of the society generally, and in particular to cause him to be regarded with feelings of hatred, contempt, ridicule, fear, dislike or disesteem. Importantly, under the Bharatiya Nyaya Sanhita 2023, defamation is a crime under Section 356. Section 356 states that whoever by words, either spoken or intended to be read, or by signs or by visible representations, makes or publishes in any manner any imputation concerning any person, intending to harm or knowing or having reason to believe that such imputation will harm the reputation of such person, is said, except in the cases hereinafter expected, to defame a person. Kinds of defamation. Dear listeners, defamation is of two kinds, libel and slander. However, this distinction is found only in England and not in India. As per Blackstone, libel consists of a written statement including a printed picture, caricature, film or effigy that subjects a person to hatred, contempt or ridicule in the eyes of people in general, whereas a slander is a false statement that is made verbally or with the help of gestures. From this, we can infer that libel is in some permanent form, whereas slander is in spoken words or gestures. Furthermore, libel is actionable per se, whereas in the case of slander, the plaintiff has to prove that damages have been suffered actually. Essentials of defamation. A defamatory statement referring to the plaintiff must be made. A statement is considered to be defamatory if it leads to public hatred, contempt, ridicule or disesteem, or excites adverse opinion against the plaintiff, or negatively impacts his profession, business or trade, and causes him to be feared, shunned or avoided by the society. In the case of Noor Muhammad versus Muhammad Ziauddin, 1992, the bridegroom and his father refused to take the bride after marriage in front of a large number of guests who had come to the wedding. The court held them responsible for defaming the bride and her family. In the case of Ramdhara and another versus Fulvabati Bai, 1969, while discussing whether a statement is defamatory or not, the court observed that it depends upon the right-thinking members of the society. The standard is to be applied in such cases is from the perspective of a right-minded citizen of ordinary prudence who is of fair average intelligence and not that of special class of persons. In the case of Deepak Kumar Bishwas versus National Insurance Company Limited, 2006, the appellant was engaged as counsel by the insurance company in an arbitration matter. The awards passed had become a rule of the court. However, the appellant failed to make any communication to the insurance company regarding the same. Hence, delay was caused by the insurance company in presenting an appeal against the award. The insurance company filed a condonation petition through another counsel who stated that the delay had occurred on account of laches on the part of the lawyer who was conducting an arbitration case before the arbitrator. The question before the Guwahati High Court was whether the said words amounted to defamation. The court held that the said words were not necessarily made to cause any harm to the personal integrity or reputation of the appellant, and the insurance company had no motive to defame the appellant, so the statement was held not to be defamatory. The statement must be published. Dear listeners, publication is a very important aspect of the law of defamation. Publication literally means making the matter deliberately known to some other person other than the plaintiff. In the case of D.P. Chaudhary and others versus Kumari Manju Lata, 1997, the brief facts of this case are that a newspaper published a report that Kumari Manju Lata had eloped with a boy without verifying the authenticity of this news from the police station. Due to this false news, the woman and her parents suffered grave humiliation. The defendant newspaper was held liable for defamation. In the case of Arumuga Mudaliar versus Annamalai Mudaliar, 1966, two persons jointly wrote a letter containing defamatory matter that concerned the plaintiff and sent the same by registered post to the plaintiff. The question was whether there was any defamation. It was held by the court that there was no publication by one tortfeasor to the other, as there could be no publication between the joint tortfeasors. Hence, defamation did not take place. Defenses in an action for defamation. Dear listeners, justification or truth, fair and bona fide comment, privileges and apology are the defenses in an action for defamation. In the case of Radhesham Tiwari versus Eknath, 1985, the defendant, who was editor, printer and publisher of a newspaper, published a series of articles against the plaintiff, a block development officer, alleging that the plaintiff had issued false certificates, accepted bribes and adopted corrupt means in different matters. In an action for defamation, the defendant could not prove that the facts published by him were true, and thus he was made liable for defamation. With reference to fair comment as a defense, an important case is Gregory versus Duke of Brunswick, 1843. In this case, the plaintiff, who was an actor, appeared on the stage of a theatre. However, the defendant, along with other men, maliciously hissed and hooted at the plaintiff and thereby caused him to lose his engagement. It was held that as hissing and hooting were a part of a conspiracy, they were held to be actionable and it did not amount to a fair comment on the plaintiff's performance. Malicious prosecution. Malicious prosecution is an abuse of legal procedure. In the case of West Bengal State Electricity Board versus Dilip Kumar Ray, 2007, malicious prosecution was defined as a judicial proceeding instituted by one person against another from wrongful or improper motive and without probable cause to sustain it. It is said to be a prosecution on some charge of crime that is willful, wanton, or reckless, or against the prosecutor's sense of duty and right, or for ends he knows or is bound to know are wrong and against the dictates of public policy. In simple words, we can say that malicious prosecution consists of instituting unsuccessful criminal proceedings with a malicious intent. In the case of Abrat versus North Eastern Railway Company, 1886, the court observed that in an action for malicious prosecution, the plaintiff has to prove, first, that he was innocent and that his innocence was pronounced by the tribunal before which the accusation was made. Secondly, that there was want of reasonable and probable cause for the prosecution, or as it may be otherwise stated, that the circumstances of the case were such as to be in the eyes of the judge inconsistent with the existence of reasonable and probable cause, and lastly, that the proceedings of which he complains were initiated in a malicious spirit, that is, from an indirect and improper motive and not in furtherance of justice. Essentials of the tort of malicious prosecution. Firstly, that the plaintiff was prosecuted by the defendant. Secondly, that the prosecution proceedings terminated in the plaintiff's favor. Thirdly, that the defendant had acted without reasonable and probable cause. Fourthly, the defendant was activated by malice. And lastly, that the plaintiff suffered damages due to such malicious proceedings. In the case of Pannalal versus Sri Krishna, 1955, the defendant did nothing beyond making a statement to the police disclosing the participation of the plaintiff in the alleged dacoity and thereafter did not do anything. It was held that the prosecution was launched by the police. Hence, acquittal of the plaintiff in the dacoity case did not give him a right to cause of action against the defendant for malicious prosecution. Furthermore, in the case of Dattarai Pandurang Datar versus Hari Keshav Gokhale, 1949, the brief facts were that there was a theft in the defendant's jewelry shop, and in the first information report registered by him with the police, he expressed doubt that the plaintiff, who was employed in the defendant's shop, might be involved in this theft. On the basis of this, the police arrested the plaintiff and produced him before the magistrate, who ordered his police custody. In the absence of any definite evidence, the plaintiff was later discharged. Thereafter, the plaintiff sued the defendant for malicious prosecution. Dismissing the suit, the court held that the very essential requisite for an action for malicious prosecution is that the plaintiff was prosecuted by the defendant. This was not true in the present case because the defendant had done nothing further than merely expressing doubt about the possible involvement of the plaintiff in the theft in his jewelry shop. The subsequent proceedings, including the plaintiff's prosecution, were done by the police, and therefore it could not be said that the plaintiff was prosecuted by the defendant. What is important to note is that an action for malicious prosecution does not lie against the executive or a quasi-judicial order. In the case of D.N. Bandyopadhyay versus Union of India and others, the plaintiff was found guilty of disobedience and misconduct and was punished by withholding the official annual increments for 2 years. In an appeal against the findings of the departmental inquiry against him, his guilt and penalty were maintained by the appellate authority. He filed a suit against this order in the district court and it was dismissed by the court. Thereupon, the appellant moved in appeal before the High Court of Rajasthan. The High Court dismissed the appeal and held that in order to succeed in an action for malicious prosecution, a complaint must have been filed before a competent judicial authority. A competent authority in a departmental inquiry does not pass a judicial order. Instead, it is mainly an executive order, and therefore it cannot be said that law has been set in motion against the person. Hence, an action for malicious prosecution is not maintainable in the instant case. The ulterior motive of the defendant in launching the prosecution is very important. In the case of Abdul Majid versus Harbans Chaube, a person was prosecuted under Section 412 IPC for keeping a chopper in connection with a dacoity case. The station house officer of the police chowki, in connivance with 2 other people, cooked up a false story that a chopper was recovered from the accused's house. The court acquitted the accused by giving him the benefit of the doubt. On being sued by the accused for malicious prosecution, the court held the police officer liable as it was actuated by malice to avenge his enmity with the accused. As a remedy for malicious prosecution, the plaintiff can claim damages. The damages are to be determined keeping in mind the harm caused to his person, reputation or property. He may also claim additional costs for the money spent on litigation. Difference between malicious prosecution and defamation. Dear viewers, as already discussed, the tort of defamation is designed to protect a person's right to reputation, whereas the remedy for malicious prosecution is more extensive as it seeks not only to protect the reputation of a person but also his personal liberty and property. Furthermore, in the tort of defamation, the plaintiff has to only show that the false statement made by the defendant against him lowered his reputation in the eyes of the right-thinking members of the society, whereas in the case of malicious prosecution, the plaintiff has not only to prove criminal proceedings instituted by the defendant against him without any reasonable and probable cause, he has also to prove certain other points like termination of the proceedings in his favor, involvement of malice, and damage caused to him. Dear listeners, now we shall discuss the tort of nervous shock. Nervous shock refers to psychiatric harm suffered by a person due to the negligent or intentional acts of another person. To understand this, I shall discuss the case of Williamson versus Downtown, 1897. In this case, the plaintiff's husband had gone to the races for the day and the defendant came to her house and falsely told her that her husband had an accident and was lying in a hospital with both his legs broken. On hearing this, the plaintiff suffered nervous shock and she became ill. It was held that the defendant had willfully made the statement to cause mental distress to the woman and hence he was liable for causing nervous shock to her. In another case of Hinds versus Berry, 1970, the plaintiff, a lady, was enjoying a picnic in the park by the side of the road along with her husband and 4 children. When the plaintiff with his younger child had gone across the road to bring flowers and her husband was preparing tea with the help of the children, the defendant's negligently driven car went off the road and knocked down her husband, causing his instant death, and the children were fatally injured. The blood had scattered around the scene of the accident. When the wife returned and saw her dead husband and injured children, she suffered severe mental shock. She got 1,500 pounds for the death of her husband and 4,000 pounds for nervous shock and mental depression caused to her for 5 years. In determining the liability for nervous shock, the court considers the forcibility of the consequential injury. In the case of Alloc versus Chief Constable of South Yorkshire Police, 1991, 16 persons who suffered no physical injuries but persistent psychiatric injury claimed damages against the Chief Constable. They were relatives of the persons killed or injured in a disaster. Some of them were present in the stadium but not in the disaster area. They had a nervous shock caused to them by listening to the news. One of them had 2 brothers dead, but he was away from the disaster scene. Liability for nervous shock was ruled out because there was nothing to show a sufficiently close degree of relationship between the brothers. In the case of Boar Hill versus Young, 1943, a motorcyclist, while negligently driving at an excessive speed, collided with a motor car and was killed. The plaintiff, a fishwife, standing about 45 yards from the point of impact, heard the noise, although she did not see the accident, and suffered fright, causing in shock, which disabled her from carrying on her routine work for some time. At that time, she was 8 months pregnant, and about a month later, she gave birth to a stillborn child, holding the injuries sustained by her responsible for the condition of the child. It was held that the action for nervous shock was not maintainable on the ground that the woman plaintiff was so far away from the scene of the collision that no duty to be careful to her had arisen, although he would have been made liable if he had caused nervous shock to any person within the area of danger, that is, within the fair limit of the place of incident. The shock resulting to the plaintiff, situated as she was, far away from the place of accident, did not fit in the area of potential danger. In the end, I would like to say that, as discussed in today's lecture, sometimes a person may not only be physically harmed, but may also suffer harm to reputation as well as harm to their psychological well-being. The main objective behind the law of torts dealing with defamation, malicious prosecution, and nervous shock is to ensure that the plaintiff is able to get the desired remedy whenever, due to the ill will of the defendant, harm to his reputation, physical integrity, or psychological health takes place. With this, we come to the end of today's lecture. Thank you very much.